On the call, on the webinar today, Victoria Carson, Cindy Price from our Bretton Woods campus, Kathy Riebel from our Raybrook campus. And so we're really happy to have them. If you've missed any of our previous webinars, they are online. They are on our resources page at Holland Home. So hollandhome.org/resources. Some of you may have registered on that page for this webinar. We have 5 others that have been very popular: an overview of the continuing care agreement, a tour of Bretton Homes, a tour of apartments, resident panel interview, downsizing, how to do that, the real estate market, vibrant living. So a lot of cool resources for you. So, and we want you to mark your calendars. Our next webinar is going to be on April 28th. And that's going to feature some new things happening at Bretton Woods, some things that we haven't even released yet. So some pretty exciting stuff coming down. So mark your calendars for that. We'll follow up with you after today's event. If you have ideas for a future webinar, we're all about new ideas and what's the best. So if you have an idea, when either myself or Cindy or Victoria or Kathy call you, just let us know that. But we're really excited to have Linsey Gleason with us today from Varnum Law. She's an estate planning attorney. She's been with Varnum since 2008. She got both her undergraduate and law degrees from Michigan State. I think I'm supposed to say go green when I do that.
White.
And not bad for an Ohio State guy. You know, I know the lingo here. Linsey's been named 50 most influential women in West Michigan in 2020 on the list of best lawyers in America, Grand Rapids list of top lawyers in Michigan. In addition to her daytime gig at Varnum, she is chairperson of the Grand Rapids Public Museum Foundation, sits on the board of Senior Neighbors, so she's very passionate about seniors. She has served on our foundation board here at Holland Home as well, so she knows us here pretty well. She also serves on the YMCA board of directors and on the cabinet campaign for Grand Rapids Whitewater. So we don't know when she sleeps, but she's awake right now for us to have this presentation. She'll be able to answer some general questions for you today, but not any detailed or offer some specific legal advice. When we get to that portion, she may say, "Hey, can't go down that deep." So let us know. She'll let us know that. If you could type any questions you have into the question and answer portion, not the chat, because we don't always see that. So if you could do the question and answer box, that would be great. And with that, I'm going to turn it over to Linsey.
All right. Thank you, Michael.
My
Good
pleasure.
morning, everyone. It's a pleasure to be here. I am going to work on trying to share my screen here and show you a little presentation that I put together that I call Estate Planning Essentials. So this is just going to give you a quick overview of the estate planning process, what that means. Let's see if I can get this working. All right. Michael, does it look like it's working for you there? You can see my screen?
Looks perfect, Linsey. Looks
excellent.
Perfect. Yeah.
Technology win for the day.
Yes, but for both of us. So
yes.
Good thing we have millennials on the call to help us.
Absolutely. Well, we're getting used to this virtual world. So today I'll be spending just about 15 minutes, maybe even less, just giving everybody a quick overview of what is estate planning. What do we mean when we say estate planning? What issues does estate planning encompass? And then I'll get into some details on those different components of estate planning and the main documents that comprise a complete estate plan. And today we're not going to go into things like Medicaid or long-term care planning, and those are whole different topics and much longer webinars. So this is just really estate planning essentials, the 101 version. So estate planning could mean many things. I'm sure you've all heard that term. Is it planning for incapacity? Is it planning for death? Is it about what your legacy will be, or preparing or protecting the next generation for inheriting wealth? And really, it's all of those things. So a typical estate plan is the decision-making process in documenting your decisions related to your care, should you become incapacitated, and then the eventual management and distribution of your assets, whether that's a result of incapacity and following death. So estate planning, generally, we are addressing those two main topics through a number of documents. So I like to give an example of what planning for incapacity means. So a good example is what happens if you have a stroke and you're not able to care for yourself any longer. And more importantly, or from the estate planning context, is if you can't make decisions for yourself, you're not able to articulate what you want for your care plan. If you don't have an estate plan in place, this is something that we often call living probate. So this means we have to go to the probate court where we ask the judge to make decision or to make those plans for you. There are two main roles that the probate court would have in this context. One is called conservatorship, and the other is guardianship. And you've probably heard these terms before, same terms that we use for minors. But there's another whole process that the court goes through when we have what we call a legally incapacitated individual. So again, someone's not able to make their own medical or perhaps financial decisions anymore. So the conservatorship is a tool that the judge uses to appoint a conservator who can make financial management decisions. So help an individual with their finances and their bill payment. And a guardianship is the appointment of a guardian to make medical, placement, and other care decisions for a person who doesn't have a plan in place. We generally think of living probate as something we want to avoid. You don't have that control. You haven't gotten to choose who you want to be in that position ahead of time. It can be very emotionally distressing for families. Sometimes we'll see arguments between families over which child is the best person to make decisions for mom or dad, or who should be managing those finances. It can get expensive, particularly if there's a dispute between anyone over who should be in charge, who should be in these roles. And there's ongoing court involvement. So if a conservator or a guardian is appointed, every year at least reports have to be filed with the court and approved. And so this is a process that will continue for that person's lifetime or until they recover, if that's possible. The good news is it's easy to avoid living probate. There are two main estate plan documents that allow us to do that. One is called a durable power of attorney, and this document can generally eliminate the need for a conservator. So instead of having the court appoint someone, you get to pick in advance and document who you want to make those financial and legal decisions on your behalf, particularly should you become unable to do that in the future. This power of attorney, you can put it in place now and it will last for your whole lifetime, even if you do become incapacitated. You get to pick who your agent is. This person is also sometimes called an attorney in fact, and that's the person who can make financial and legal decisions on your behalf. They can really stand in your shoes, but you can pick those range of power. So it's common to say, my agent can do anything that I could do from a legal or financial standpoint, but you can also do a limited power of attorney where you can just pick, these are the certain things I want my agent to do for me. And this is much less expensive than having to go to the court and get a conservator appointed. It's a simple, just a few page document. Then the other document to avoid living probate is, in Michigan, we typically call it a designation of patient advocate and living will. In Florida, we call it a living will and designation of healthcare surrogate. You often hear this referred to as a healthcare power of attorney, advance directive. So it has lots of names, and there are lots of different ways that you can put this in place. But the idea here is that you're picking your own patient advocate or your healthcare surrogate, or that person who's going to step in to make medical decisions for you if you're not able to convey what your own decisions are. Again, this is much less expensive than having to go to court. It generally avoids the need for a guardianship at all. And you can, again, pick who you want to make your decision. And that living will portion, you're able to guide your patient advocate of the kind of decision you'd want them to make. So you can say, to me, it's important that I, wouldn't be in a vegetative state for many years if I'm not going to recover. You can tell your patient advocate, in this situation, here's the decision I want you to make for me. The one thing I'd note is this is different from a do not resuscitate order or a DNR. There's a range of different healthcare directives that you can put in place. This one is the main component here is that you're picking your patient advocate or the person who will be your spokesperson if you can't make your own decisions in the future. But again, it's different than a do not resuscitate order, although that can be part of your estate plan too, and something you discuss with your estate planning attorney, but more importantly with your physician. So that's a quick overview of planning for incapacity. I think that's the often overlooked component of estate planning, but it's very important to have that in place. And it's very easy to document your wishes through your power of attorney and your designation of patient advocate. The thing that I think most of us think about when we talk about estate planning is planning for death and how we're going to transfer assets when someone passes away. So there are a few different ways that assets can be transferred on death. One is called probate. The thing I think to understand there is that can happen if you have a will, or even if you don't have a will. That's called intestacy. The probate court still governs even if you do have a will. I think there's a conception out there that if you have a will, your assets don't go through probate, but that's not true. A will is a direction to the probate court of what you want to have happen with those assets. And if you don't have anything in place, still go through the probate court. Another way to transfer assets on death is through joint ownership. Talk a little bit more about that in a moment. Via beneficiary designation, so that's a common way to pass a retirement account like an IRA or a life insurance policy. And then a trust. So a lot of what an estate planning attorney assists with is documenting your wishes through a trust. So I'll talk a little bit more about probate. Probate governs the transfer of assets that are titled in a person's individual name when that person passes away, so long as there is no beneficiary designation. Again, probate also applies if you don't have a will or you die what's called intestate, and it applies to wills. And another important thing to point out with wills is a direction in your will does not apply to assets that don't go through probate. So you can have a will that says, all of my assets go to my brother, but if you have a life insurance policy and the beneficiary is your sister, the will not override that and give the assets to your brother. The beneficiary designation is going to govern. So a will only applies to assets that actually have to go through probate because there was no joint owner or was no beneficiary. There's some disadvantages of probate as well. Just like the living probate we talked about, you have to go through that probate court. It could be expensive, though it's not necessarily guaranteed to be. It takes some time. It takes a minimum of 5 months to go through that probate process. Everything is all public record down at the probate court. And actually now we do our probate court hearings on Zoom and the public can pop into those. And it's also possible that there can be multiple probate proceedings. So you could probate an asset and down the road, a year later, you find that there's another asset that you didn't know about. So it's not necessarily a smooth, streamlined process that you just do once. Occasionally, we want court supervision for some reason, like there are disputes. So occasionally we think going to the probate court can help make sure we've got oversight by that judge. But I would say that's rarely an advantage, but it's possible. It's easy to avoid probate, and there are a number of ways you can do that. One is by having assets titled jointly. This is very common between spouses. If you've got husband and wife who own a property together, one of them dies, the other one just owns that asset automatically. Nothing really needs to be done. However, that only happens once. When the survivor then dies, if that asset was just in their name alone, now we've got to probate it. So you'd have to keep adding another joint owner, which can create some issues. I often counsel my clients to be very careful with joint ownership. One, the IRS can say that once you make an asset joint, you've made a gift. So you've given that person an interest in that asset. And the IRS wants to be informed when you make gifts over a certain value. There can also be some liability concerns. So I always tell my clients, be very careful before you make somebody joint on your bank account. Number one, not only are you giving them access to your bank account, but if they have some sort of creditor issue, they get in a car accident and get sued or get divorced, that person's creditors can now look at your assets because you put their name on your assets. So you want to be very careful with joint ownership. Beneficiary designation is an easy way to avoid probate. And this is a great idea, again, for things like retirement accounts, like your IRAs and life insurance policies. You just have to be careful that your beneficiary is still living when you pass away. If your beneficiary has predeceased you, then they're not going to be able to take that asset. And you also need to be careful if your beneficiary is a minor or might be incapacitated, you have special needs or not able to manage that asset on their own. But for many assets, that's a great option. Another common way to avoid probate is by setting up a trust. I think there's a conception that trusts are for very wealthy people, but trusts are very common vehicles for transferring assets. We call them will substitutes. And we say it's kind of like a box. You put your assets into your trust and your trust doesn't die. So when you pass away, it doesn't have to go through probate because it's still in this other entity. So it's a way to hold that title. You have to fund your trust by putting assets into that box, but if you do it properly, nothing happens during lifetime. It's a very easy process during life. You should avoid the probate court getting involved as long as those assets are in the trust. And you get to pick who your trustees are and who your beneficiaries are. And you've got a lot of flexibility there. You can control all of those decisions. It avoids having to go through the probate court process and all the expenses associated with the court filing fees and the legal fees. And there can be some tax benefits. I won't get into that today, but for very wealthy people, there can be some ways to minimize estate taxes and maybe capital gains taxes and other things there. When you set up a trust, the thing that you do have to pay attention to is your fiduciary or who your trustee is. So who you're going to trust and manage that process. So when you die, your trustee will take over all of those assets, liquidate things as appropriate, make sure funeral expenses get paid, and make those distributions. You'll need to think about who your beneficiaries will be and how and when they might receive those assets. So if you wanted money to go to children or grandchildren, are they old enough to manage that money responsibly? And then you should think through charitable gifts. What kind of legacy do you want to leave to your family, to your community? And we can document that in your trust as well. So a little overview of planning for that trust. You need to think about who you want to be in charge, who's going to honor your requests and your intent. And if you're setting assets aside for children or grandchildren, you want to be intentional about, well, what's going to happen if my child goes through a divorce or has a substance abuse issue? Or am I worried that by them getting this money, they're not going to be motivated to keep being a productive member of society? Or what if they might waste it? Those are all things an estate planning attorney can help you think through in your situation. The thing that I always talk about with an estate plan is it's very personal. There isn't a one-size-fits-all plan. It's very tailored to each person's circumstances, to their assets, to their goals, and the legacy they want to leave. So your estate planning attorney will help you with a complete plan that includes typically a will, in addition to a living trust. It's not necessary to do both of those documents depending on what you own and what we can do via beneficiary designation. But I have all of my clients create a power of attorney and a designation of patient advocate. And the thing I like to stress that the best time to do that is now. It's sooner rather than later. You don't want to be going through this process when there's a stress of an illness or a spouse who's ill. You want to do it early so that you can really, again, be intentional, take the time to think through those decisions, again, without other stressors on you, and again, illness. So those are my recommendations. I'm happy to answer questions.
Well, thank you.
Let's see if I can turn this up.
It was very informative. I had reviewed this ahead of time, and you brought up some things I had not thought about. So it's sort of like the joint ownership thing, which was some considerations I had not thought about. So that was very interesting. I'm seeing a couple things pop in here. One thing I want to mention is that your advice, I would say, is to absolutely make a plan. Not making a plan is not making a decision is making a decision, right? And I think I remember you recounting to me someone that had said to you about doing this plan. Well, if I die, and you said, no, wait a minute, at some point, we're all facing that. It's not an if, but it's what is the plan? So let's look and see what some of these questions are. If we are moving from another state, should you have your trust reviewed?
This is an excellent question that I get a lot. And they say, yes, you should have it reviewed. It doesn't mean necessarily that you'll need to make changes, but some states do have different laws that can impact your plan. There can be different, tax rules that can be in place. There can be some different rules about having your residence owned by the trust. So sometimes certain provisions in the trust could cause an increase in property taxes. So I always do recommend that you have your entire estate plan reviewed by an attorney who's licensed to practice in that state in which you live, because the power of attorney and the healthcare directives can have some different rules too. So sometimes we determine, nope, this is fine, it's going to work here, but always good to have it reviewed.
Yeah, good. All right. Says, say a little more about, quote, funding your living trust.
Yeah. So a trust will govern and will distribute assets that are owned by that trust. So to fund the trust, there can be a little bit of homework during life to get assets retitled so they're owned by the trust. That's taking that asset and putting it in the box. So for things like real estate, we fund the trust by doing a new deed that says that the owner of that property is the trust or the trustees of the trust. For things like bank accounts, sometimes we retitle bank accounts in the name of the trust. Other times we make the trust the beneficiary of that bank account. So when a person dies, the assets then go into the trust so the trustee can access those. So it depends on the asset, but sometimes we're actually changing the title or the ownership of that asset to name your trust or your trustee as the owner. Other times we're making sure that your trust is named as the beneficiary. So that's how we just make sure those assets are in that trust, in that box when a person passes away.
Okay, great.
And again, it's very individualized, very personalized, step by step. So I sit down with my clients and we look at, what do you own? What kind of bank accounts, brokerage accounts do you have? And go through that process together.
Good. The next question, should the durable power of attorney actually be an attorney?
No, and that's, it's a strange name on that document. It definitely does not need to be an attorney. We call that person an attorney in fact, or your agent. Does not need to be an attorney. Any individual can be your agent. And occasionally we'll find, professional trustees, professional institutions that will act as trustee and sometimes agent. But most people will name as their agent, spouse, kids, friends, other trusted advisors, whoever you would really trust to say, gosh, if I couldn't pay this bill anymore, who could I rely on to handle this for me? Does not need to be an attorney or any other professional. Could be a family member. Often is.
Okay. This is a question we've gotten now twice. How often should you review your trust or your documents?
Yeah, that's another great question. It really depends on how often or if your situation is changing. So I recommend that people look at their trust at least every 3 to 5 years. It could be more often if you're in a state of a lot of change, or you are moving, or you've had a change to your family situation. Again, there's a divorce or a grandchild born with special needs, or something that's impacted how you want your assets to be distributed. But a lot of people may only change their plan a couple times during a few major life events. But I recommend you look at it at least every 3 to 5 years and just say, has any of this changed? Are my trustees still the right people? Are my beneficiaries still the right people?
Right, and that time can go quickly, like 3 years. You think, oh, and how much can change in that time, right? Even like they've moved, my beneficiaries have moved, or addresses have changed, phone numbers, all that kind of stuff. So.
Yeah, and we usually say you might not need to change any documents because of address changes for beneficiaries, or really even for you, maybe if it's within that same state. But again, it's good to take a look at it.
Sure.
Good to assess, right, your charitable goals and all of those things, because that stuff does change.
Yeah. Should you have a trust from another state reviewed in Michigan before you make the move or after you move?
I think it's probably fine to wait until after you're actually a resident. There's no harm in saying, hey, I'm planning on becoming a Michigan resident soon. Attorney, could you look this over for me? I don't think that really matters, but it's not like as soon as you become a Michigan resident that it's vital that your plan reference that you be in Michigan. So it's, anytime during that process that makes most sense to you, but I think it would be fine to do that after you actually moved.
Sure. Okay. Are there any other questions? Here's one, and this is always the one that's a hard one to answer, I bet. How much does it cost to set up a living trust?
Again, that depends because that every plan, every trust is tailor-made to that specific individual and what their goals are. So, sometimes a trust, as we call, is very simple and it doesn't require a lot of customization. Other times we have a lot of specific provisions that take a long time to customize and some complicating factors, some things that could make the process more complicated is that we've got a married couple who both have children from a prior relationship, and you want to be intentional about how those assets flow when that couple has passed away. Or again, if you have a beneficiary with special needs who's not able to manage money, that requires more time in that process, so it can be more expensive. I usually tell people an entire estate plan, so wills, trusts, powers of attorney, the healthcare powers of attorney, the funding conversations, all of that, you can usually expect that to start at about $2,500 and go up with complexity. It can be less than that, again, if things are simple or for one individual. But for a couple with a fairly straightforward plan, I would say that's probably about the cost that you'll see around the community for all of those documents.
You touched on this a little bit. This isn't from one of our participants, but you touched on it a little bit, and I don't know if you can say any more about it, but there are some that recommend, and Holland Home does not, an irrevocable trust. Can you talk about that a little bit and why that is a problem? I don't mean to put words in your mouth. Can that be a problem? How's that?
Yeah, so when we talk about estate planning, this revocable living trust is the main initial vehicle. We'll sometimes have people who will do an additional trust that's irrevocable or do an irrevocable trust in place of their revocable living trust. And it really depends on the goals. Very wealthy individuals will sometimes do irrevocable trusts to get assets out of their taxable estate. It's a way to save on estate tax. So often we'll see it in the context of Medicaid planning. And the reason why you want to be careful and make sure that that's the right fit for you is you are giving away those assets. They're not yours anymore if you put them in an irrevocable trust. And it's irrevocable. So not only can you not revoke the trust, you can't change it or amend it. So those decisions are really set in stone. So it depends on the context, the purpose for doing the irrevocable trust, whether it's good planning or might not be the best decision. So again, it's very, very fact specific, but you have locked yourself into something, and you have also likely restricted your own access to your own money.
Yeah.
That's problematic for many reasons.
Yeah, right.
It can be.
Yeah, good. There's one last question here. I think it's probably the same answer you gave before. What's the average cost for a review of a trust from another state?
So if I'm reviewing a document or maybe helping somebody amend an estate plan that's already in place, again, that's just going to be typically hourly charges. Most attorneys are going to charge that way. So it just depends on how long that process takes and what that conversation is like. I mean, it could easily be an hour of time or less, particularly if no changes need to be made. So it's possible it might just be a couple $100 for somebody to say, I might just change this one provision, or this is fine how it is. So again, it's fact specific and depends on what that document's like and what questions the client would have.
Great, good. Everyone that had registered, and I had sent a reminder out yesterday morning, has Linsey's contact information in there. So if you're interested in reaching out to her, that's an option for you. So that her contact information is in there. So Linsey, thank you. I'm going to talk a little bit about just what's going on here, just a little bit, and then we'll just see if there's any last things. But things, spring has sprung, and we're seeing a lot more activity here at Holland Home. We do have openings and discounted apartments here at Bretton Woods and also at Raybrook. So at Raybrook, we have some openings in Estates 3, 1-bedrooms, also a 1-bedroom in Estates 1. Life care starting at $88,000. So if you think about that, making that plan, that is a pretty, life care is really all part of that whole overview of planning for the future. We are doing tours. We have actually been fairly busy the last several weeks, and the phone has been ringing, which we're grateful for. A lot of our people are deciding to move now because the real estate market is hot, like hotter than it's ever been. We were saying yesterday, I don't think there's no way it could get any better. So it's about as good as it's ever going to get. And we do, like I said, have some discounted apartments through the end of May. So if you signed a reservation by the end of May, moved in the summer, you still lock in that price. So do remember, mark your calendars for our next webinar, April 28th. Linsey, anything else you want to add?
No, it was a pleasure. And as Michael said, everyone can feel free to reach out to me with further questions. Happy to help.
Good. Well, again, thanks for joining At Home with Holland Home, and we hope you have an awesome, awesome day. Take care.
Bye, everyone.
Bye.